Good afternoon. Barnes County District Court is now in session this June 19, 2026. The time is now 1:23 p.m. My name is Nick Thornton. I am a district court judge for the Southeast Judicial District, which includes Barnes County. We are conducting this hearing by reliable electronic means. It is venued in Barnes County. The Barnes County Courthouse is visible from the court's Zoom screen. The Barnes County Courthouse is open to the public. These are open and public proceedings. The matter on the court's docket this afternoon is State of North Dakota versus Sandy Renetta Kemp, 02-2026 CR 143. Present in court by reliable electronic means, Attorney Tanya Duffy for the state. Present in court for the defendant by reliable electronic means, Attorney Erica Chisholm, making a special appearance for this initial appearance. The defendant also appears by reliable electronic means from the Stutsman County Correctional Center. All right. Ma'am, it looks like you might be muted at the Stutsman County Correctional Center. Can you unmute your microphone for me? I think you just remuted it.
It should be good now. It should be good now.
Yep, so just leave it alone now. Thanks. So, ma'am, were you present in court when your rights were just read to you?
Yes, I was.
Do you understand your rights?
I understand them fully.
All right, so when a person appears in custody at their initial appearance, the law now presumes that you are indigent and automatically appoints you a public defender to represent you for today's hearing only. You do have the right to hire a lawyer. You have the right to apply for a public defender to help you with the rest of your case. And if the court finds that you financially qualify for a public defender, one will be appointed to you, or you can choose to represent yourself. Do you understand your right to counsel?
Yes, I do.
All right. So what is your plan for counsel for the case here? Do you plan on hiring a lawyer? Do you plan on applying for a public defender? Do you plan on representing yourself?
I want to see how the case goes first.
Okay, so Ms. Chisholm will help you today, but after that, you'll need to make a decision on how you want to move forward with respect to your right to counsel. Do you understand that?
Yes, I do. Thank you.
Have you received a copy of the charging document in this case?
No.
I'm going to share my screen so you'll see it on the screen. You won't see my head anymore. So give me just a moment here and I'll share my screen. Can you see that document now, ma'am?
Yes.
All right. Is your name spelled correctly in the upper left-hand corner of that document?
Yes.
You have the right to have this document read to you in its entirety, or I can summarize the document for you. Which would you prefer?
Summarize for me. And can I have a copy? I never got that.
Yeah.
You
I never
will
got
get a
it.
copy. You will, but I will summarize the charges and this charging document. So the state alleged in its criminal information that you committed a total of 5 criminal offenses. Before going on the record, the court reviewed the declaration of probable cause, and I did not find probable cause with respect to count 2. So I'm going to skip count 2. I did find probable cause for the remaining 4 counts. And Ms. Duffy, just for your information, the reason I did not find probable cause with respect to count 2 is that the charge is hindering law enforcement, which requires intentional interference, hindering or delaying or preventing the discovery, apprehension, or prosecution or conviction or punishment of another. Here, this was a false name case, so she was hindering her own apprehension or arrest. So I don't think it meets the definition under the statute. It very well could be a different offense, but not hindering, so I did not find PC for count 2. Ms. Kemp, in count 1, the state alleges that on or about June 18, 2026, in Barnes County, you committed the Class C felony offense of theft of property by knowingly receiving, retaining, or disposing of property that had been stolen with the intent to deprive the owner thereof, and the value of the property exceeded $1,000, but not more than $10,000. In particular, what the state is talking about here is the vehicle the state alleges you were in possession of that had been stolen. As charged, ma'am, what are you doing? I see
She
you
flipped me off
gesturing with your
twice.
hands.
She flipped me off twice.
Okay,
No,
so stop. I need you to focus on
All right.
me. All right,
Okay.
so don't look anywhere else. And you need to stop gesturing with your hands. Focus on the proceedings, okay?
Okay.
So you're charged in count one with a Class C felony. The maximum penalty is 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any applicable minimum mandatory penalty with respect to count one, other than fingerprints and a DNA sample, and court fees totaling $525, and the potential for restitution. We're going to talk about that with respect to all of the offenses in a bit. In count two, again, the court did not find probable cause, so we're skipping count two. Count three, the state alleges on or about that same date, June 18, 2026, in Barnes County, you committed the offense of unauthorized use of a vehicle by knowingly taking a vehicle that you did not have the consent of the owner, and that you were operating and exercising control over that vehicle belonging to another. That is charged as a Class A misdemeanor. Class A misdemeanors carry with it the maximum penalty of 360 days in jail, a fine of up to $3,000 or both. Again, the state has not alleged any applicable minimum mandatory penalties other than a requirement that you submit fingerprints, and court fees associated with the Class A misdemeanor total $325. Counts 4 and 5 are both Class B misdemeanors. In count 4, the state alleges that on or about June 18, 2026, in Barnes County, you committed the offense of reckless driving by driving a motor vehicle recklessly in disregard of the rights or safety of others. Again, this is a B misdemeanor. And count 5, the state alleges that on or about June 18, 2026, in Barnes County, you committed the offense of driving under revocation, in that you were driving or operating a motor vehicle on a public or private roadway, and at the time your license was suspended or revoked in any jurisdiction. Both counts 4 and 5, again, are Class B misdemeanors with a maximum possible penalty of 30 days in jail, a fine of up to $1,500 or both. The state has not alleged any applicable minimum mandatory penalties other than fingerprinting. Court fees associated with a B misdemeanor total $250. For all 4 counts that I found probable cause for, if your conduct caused any loss or financial harm to another person, the court can order restitution. If you are not a United States citizen, a conviction of any of these offenses can result in significant adverse immigration consequences. And lastly, if you're convicted of any of these offenses, there may be significant collateral consequences that the court is not required to explain. An example of collateral consequence would be if you're convicted of either counts 4 or 5, there would be administrative driver's license consequences likely resulting in a consecutive suspension or administrative application of points against your driving privileges. Do you understand the nature of the charges against you and the penalties as I've read them, ma'am?
Yes, but I cannot submit to the fingerprint.
Yeah, okay, that's a minimum mandatory, and I want you to understand that that's going to happen. So, but do you understand the penalties and the charges?
Yes, I do. And
All right.
also,
So stop.
sorry.
I'm going to give you an opportunity to speak, but now is not that time. Because you are charged with a felony in count 1, I am not going to take a plea of any kind, not today. That decision will happen later after a preliminary hearing. So for now, I'm going to stop my screen share so you can see me again. All right. So your next court date for that preliminary hearing, Ms. Kemp, is July 28, 2026 at 1 p.m. Central Time. That date again, July 28, 2026 at 1 p.m. Central Time in the Barnes County Courthouse in Valley City, North Dakota. Do you understand when you next need to be in court? And you're going to get that date in writing. You gave me a thumbs up, so
I got it. I got it.
okay, July 28 at 1
July
p.m.
28th
Central.
at 1 p.m. Central. I will be here early.
Okay, well, that's
Promise.
good. That's good. So the only issue that we need to address yet today is I need to set your bail. And the way that works is I'm going to hear from Miss Duffy. She's going to give me a bail recommendation. Then I'll hear from Miss Chisholm, and she'll give me a bail recommendation. And then lastly, ma'am, I'll give you an opportunity to speak on bail if you wish to be heard on it. Miss Duffy, your thoughts on bail?
In this case, Your Honor, the defendant, I'm not sure if she has a continued ongoing mental health crisis that's still ongoing. The state received communications from Stutsman County that she was having conversations with herself even this morning yet, and was refusing to be booked in. So it appears that that process has completed because she's wearing orange. Her behavior today demonstrates to me that there's a mental health crisis. I don't know what kind, but that there's something going on. So I'd ask the court to order an evaluation for that to address that. Probably we could be efficient as well and order a fitness to proceed and a criminal responsibility. It sounds like the behavior was exhibited during the trooper's initial interaction as well. So once that's completed, I think we could have a better understanding of where this case is going to go. In the meantime, as far as the bond recommendation, the state would recommend, it appears she's from Nebraska. I don't know that she has any ties to North Dakota. It sounds like she was just passing through after this vehicle. She'd allegedly taken the vehicle. And so I don't think she has any ties to Barnes County other than she was just passing through. Her ties appear to be to, like I mentioned, Nebraska. She talks about flying other places. I don't know if any of that's true or not true. That part I'm not sure, but her driving behavior that she was alleged to have engaged in is also concerning on the community side, based on how fast she was going in a residential area. So with that, anyway, I would ask the court to set bond at $5,000 cash, or on the alternative, a $50,000 surety. And then additional conditions, including no leaving the state. If she chooses to have an attorney, that she maintains regular contact with them. No contact with the victim in this case. And then just the standard conditions that she remains law abiding and comes to court when she's supposed to.
Well, 5,000, 50,000.
Yes. And no contact.
And the individual's name for the no contact order?
Is Logan, I think it's Bodeker, B as in boy, Oeddeker.
Who?
All right. Anything else, Miss Duffy?
No, Your Honor.
Boeddeker.
2 Ds. Yep. If that's what you said, you cut out on my side.
2 Ds or 2 Ks?
It's B as in boy, O, E as in egg, D, 2 Ds as in dog, E as in egg, Ker.
I don't know who that is.
right. Ms. Chisholm, your thoughts on bail?
Thank you, Your Honor. Obviously, I have not had an opportunity to speak to Ms. Kemp, and I have very limited information regarding her actions and behaviors in regards to this alleged incident, as well as her behavior this morning at the jail. But I do share in the concern regarding her competency at this juncture, Your Honor. Without additional information as to her mental health, I'm concerned that a fitness examination
At the door.
might be necessary,
Trying to
Your
get
Honor.
in. No, he's standing right there. I see him.
And I would ask the court to defer to Ms. Kemp in relation to her finances.
Thank you. Ms. Kemp, you have the absolute right to remain silent. Anything you say can and will be used against you. If you choose to exercise your right to remain silent, that silence won't be used against you at today's hearing. It won't be used against you in my determination of bail. It won't be used against you later in these proceedings. It can't be used against you in any way. If you choose to make a statement concerning bail, please be advised that these proceedings are recorded. And again, the prosecutor can get a transcript of the proceedings and use any statements you make against you in either today's proceeding or later proceedings. Do you understand the warning the court just gave you?
Yes, I fully understand.
So if you make a statement concerning your bail, I would ask that you limit your comments to that of which what are you asking the court to set bail at and why, without talking about the facts of the offense, okay?
Yes, sir.
Is there anything you want to tell me concerning bail before I make my decision?
Before that, could I see the public defender, please?
Ms. Chisholm, you want to unmute or turn your camera on so she can see you?
Certainly, Your Honor.
And Ms. Kemp, are you asking to speak with Ms. Chisholm privately? Is that what you're asking?
I can speak to you, Judge.
Okay, so you can see Ms. Chisholm now. Is there anything that you want to tell me before I set bail?
Yes. If you could lower bail, that would be very much appreciated. Oh, and also, if I can get a PR bond, I'm just trying to get home. I'm just trying to get through here. I was on my way to catch a flight. I'm not even supposed to be in this shell, and I'm going to be in trouble for not being where I'm supposed to be. So I don't want that to be my fault. And if you could lower the bail and give me a PR bond, I promise I will be back to court on that day. I will be here. Thank you.
Where were you trying to catch a flight to?
I can't dispose that. I'm sorry.
So do you
California.
understand that?
California.
Okay. And what was the plan in California?
Well, I had my clothes and everything, and I was gonna get my daughter, and we were gonna go to California for a vacation. I have my bag packed, and I also have a beach bag and my beach stuff and all that stuff in there that they went through. And they can corroborate that's in those bags also.
So why would you be in trouble if you weren't able to make a vacation?
Because I'm supposed to be there. And I'm not supposed to be here. I wasn't supposed to be stopped at all.
Anything else, ma'am? Ma'am, is there anything else you want to tell me?
Just what I said earlier, and thank you, Judge, for listening to me.
You're welcome. The court has considered the constitutional provisions concerning bail, including Article 1, Section 11 of the North Dakota State Constitution that says all defendants are bailable upon the posting of sufficient sureties. The court has considered Rule 46, including Rule 46A, which has a presumption of release on one's personal recognizance or unsecured appearance bond, unless the court has before it sufficient evidence or information to rebut the presumption. that an unsecured appearance bond or personal recognizance would be sufficient to ensure the defendant appears in court. Here, it appears to the court that the defendant lacks ties to the community, lacks ties to the state, was traveling through, and doesn't have adequate ties to the community, had plans to leave the jurisdiction and go to the state of California, appears to have connections to the state of Nebraska. The court has sufficient evidence before it, despite defendant's promises to appear in court, allowing the court to rebut or allowing the court to conclude that there's sufficient evidence before it to rebut the presumption of release on unsecured or personal recognizance. The court also has concerns based on the declaration of probable cause and the defendant's behavior in court, including rather insistent or frantic hand gestures, looking off screen, allegations about someone off screen in the jail, flipping her off. The court finds, based on that observation, that there very well might be a fitness to proceed competency issue that the court needs to be evaluated. For those reasons, the court doesn't believe the defendant will appear in court when required, without the posting of some bail. Here, the state has asked for a $5,000 cash bail on a felony. The court doesn't find that to be categorically unreasonable, or a $50,000 corporate surety. This is a nonviolent offense. It's a possession of stolen property case and reckless driving. The speed concededly was 86 in a 45 through a residential area, which is troubling to the court concerning community safety. The defendant's report to law enforcement at the time, as set forth in the declaration of probable cause, together with some of the statements about catching a flight to California, again, pose certain concerns to the court about the defendant's likelihood to appear. I'm going to set bail as follows, at least for the time being. $5,000 cash, or an alternative at the defendant's option, $25,000 corporate surety. I think that's sufficient. I don't think I need a $50,000 corporate surety bond to ensure the defendant appears. I think 25 is enough. Additional conditions: defendant shall remain law-abiding. Defendant shall not leave the state of North Dakota without the advanced express permission of the court. The defendant shall have no contact with Logan Bodecker. Ma'am, again, you need to focus on what's going on in court, not what's going on off screen. You shall have no contact with Logan Bodecker, either directly or indirectly, except through law enforcement or an attorney. You must maintain at least weekly contact with defense counsel. You must notify the court of any change of address, employment, phone number, or email within 24 hours of any such change. You shall not use or possess alcohol or controlled substances unless prescribed. You shall participate in and cooperate with a fitness to proceed examination under North Dakota Century Code, Chapter 12.104. You shall not possess a firearm or other dangerous weapon. You shall sign a promise to appear in waiver of extradition before release. I'm going to order you to complete a public defender application before release. You shall personally appear for all scheduled court hearings. Your next court date is July 28, 2026 at 1 p.m. Central at the Barnes County Courthouse in Valley City, North Dakota. You shall submit a DNA sample and fingerprints before release. You shall not drive or operate a motor vehicle without a valid license or privilege to do so and a valid liability insurance. Ma'am, do you understand the terms and conditions of bail as I've said it?
Yes, I fully understand, and thank you, Judge.
All right. If you remain in custody for longer than 2 days following today's hearing, you can request a bail review. A bail review doesn't necessarily mean that your bail will be lowered. The bail can go up, it can go down, it can stay the same. It just means that a judge, if you're still in jail in 2 days, can look at your bail to determine whether or not it is still appropriate. Do you understand your right to a bail review?
Yes, I do, Judge.
Anything else for the state?
No, Your Honor, thank you.
Anything else, Ms. Chisholm?
No, Your Honor, thank you.
I don't need her. Thank you.
All right.
Thank you for your services.
Yeah. So
Thank you.
you
Slow.
just- yeah. So
Doesn't tell me. You
the
don't
court,
tell me.
again, in light of the, you need to stop talking.
She
So-
told me she was
So,
talking to me.
Stop.
All right, I
You're
will.
still in court, so you talk when it's your turn.
Okay.
So in light of the late time period at this point, I don't think I'm going to get that fitness to proceed order out until next week. And so that fitness to proceed order will probably come out Monday. Ms. Duffy, just so you understand when the state's obligation to turn over discovery to the state hospital will start accruing. So if you want to start compiling it now, my order will be issued most likely on Monday, considering it's already 1:49 p.m. I don't think I'll have it done this afternoon. Understood?
Good, thank you.
All right. Anything else from any other party?
No, Your Honor.
With that, we are adjourned. Have a good day.